and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hello, and welcome back to Unpacking the Case. There has been a long line of cases where someone argues that a commercial lease has been frustrated. That means an unexpected event has changed things so dramatically that the lease should simply come to an end. It's an argument that captures plenty of attention, but it's one that almost never succeeds. This week, we're looking into Nominee 1 Limited and Study Group UK Ltd, a recent High Court decision that revisits the doctrine of frustration in the context of commercial property. Frustration is a familiar concept in contract law, but leases have always been treated rather differently. The courts are reluctant to allow parties to walk away from long-term property interests simply because the circumstances have changed. In this episode, we'll explore what the decision tells us about the very limited circumstances in which a commercial lease might ever be frustrated. Let's unpack the case. Hi, Richard.
Hello, Lizzie.
Hello. We're here to talk about a case. As per usual, that is what we usually convene to do.
Yeah.
And this time it's a case from the High Court from the 21st of May called Into Nominee 1 Limited and Study Group UK Ltd. And it's the latest in a long line of cases arguing that leases have become frustrated by some intervening act. And it also brings in some post-Grenfell legislation on fire safety matters. So, do you want to give us the background facts for this one, please?
Yeah, I'll let's say they were arguing frustration of the common purpose. And if you remember your studies, frustration is a contractual principle, but creeps into sort of leaseholds on occasion. It's where there's an unforeseen intervening event which renders substantial performance of the contract impossible. And if it's frustration of the common venture, it's basically, physically the activity is still possible, but it makes no commercial sense. The commercial reality has disappeared because of some unforeseen event. And it's got to be for the common purpose. It was a summary judgment, but the background facts, it all took place in Brighton. Study Group UK have quite a few of these places up and down the country where it's a sort of residential training school. It was a new build property and they entered into this lease. There was an agreement for lease and then a lease for 25 years was entered into in 2007. It was in Brighton. And the basic idea is that they take overseas students and sort of give them foundation basis and the like, so they can then apply for universities and this kind of thing. And the premises, as I say, it was a residential training college. It seems to comprise two separate buildings and a glazed corridor between the two. One was the kind of academic part where the training would occur, and the other was residential, which is where the problems arise. So they had this 25-year lease. In 2021, post-Grenfell, it wasn't what was considered a higher risk building, but it was over 11 metres in height. And post-Grenfell in 2017, a few years later, they checked the property in relation to fire safety and the likes and found that there were severe fire safety problems in the external cladding, as so often the case, but also cavity barriers, which retard the spread of fire, hadn't been installed. And experts also said it breached then building regulations, 2007 building regs, and if it breaches 2007 building regs, massively breaches them today. But the sort of experts, there was going to have to be remedial work, and they said that the remedial work probably wouldn't be completed until after the lease had come to an end in 2032. And so they basically refused to pay the rent and argued the contracts had been frustrated, and that's some of the background to it.
Has there been any previous case law on this?
Oh, there's been loads of cases, Lizzie, but I'll give you the one. I mean, the first, I think, case on frustration of contracts was not dissimilar. It was 1863, Taylor and Caldwell, which is about a theatre hired out for various performances, and the theatre burnt down before the performances. And that was frustrating. But in terms of sort of leasehold premises. There was a case in 1945, a House of Lords case, called Cricklewood Property and Investment Trust and Leighton Investment Trust, which what had happened is before, the years before the Second World War, sometime in the 1930s, late 30s, they'd entered into a 99-year building lease whereby they would build shops on this particular premises. And what then happened in charge of rent and the likes, but what then happened is the Second World War intervened because of wartime regulations. You couldn't build, there was massive limitations on building sort of, civil premises. So they couldn't build the shops, and they argued the contract had been frustrated, the lease had been frustrated. The House of Lords, as they were, unanimously said on the facts, there's no frustration, They didn't know how long the war was going to last. It was towards the end of the war the case was heard. But it wouldn't be lasting for anywhere close to 99 years. And therefore, it was only a small fraction of the whole, if you like, which would be affected. Two of the judges actually said that frustration couldn't apply to leases because you lease out the land, and even if the building disappears, then or you can't build the building, you've still got the land. Two of them said you could potentially, but rarely have frustration of contracts if they're leaseholds. And the other judge decided not to say anything. Then we had another case in 1981, National Carriers and Penalpina, which was a 10-year lease of a warehouse in Hull, another House of Lords case, where for 20 months, after 5 years, for 20 months, the council decided to shut down the access road to the warehouse, rendering it worthless for those 20 months anyway, because there was a neighbouring building in danger of collapse. And again, the House of Lords decided that there's a possibility of frustration, but not on the event, not on the facts here. It's only 20 months out of 10 years. And we had another case, a High Court case, which was settled before it went to the Court of Appeal, 2019. Do you remember a case? I think we've talked about it. It wasn't one of the podcasts. It was before we started doing the podcast, a case called Canary Wharf and the European Medicines Agency.
I can't remember that far back, Richard. We've been doing these podcasts so long, that must be...
Well, it was...
years ago.
It was a 23-storey building in Canary Wharf, and the European Medicines Agency, or an EU body, leased out 10 stories on a 25-year lease. There was an agreement for lease in August of 2011, and then there was the actual lease was in 2014, paying something like £13 million per annum. And when almost exactly 10 years ago, the Brexit vote occurred, and then we subsequently left Europe, they basically couldn't operate in a non-EU country. So they argued it would be a frustrating event, Brexit. It would be a breach of statute and a breach of our constitution to continue. It could have bankrupted Canary Wharf if it had been decided in their favour. The judge actually said in 2011 Brexit was an unforeseen intervening event. I doubt that actually it was being talked about in 2011. But they decided it didn't render substantial performance impossible because you could still, you could assign the lease. And the assignment, I think, was subject to somebody with equal standing or equal creditworthiness or sublet to somebody. And so they eventually sublet to WeWork. So it was all settled. But again, frustration will possibly bring the lease to an end early in your liability, but not here. And the case we did do a podcast on, I remember, and of local interest to yourself, was Bank of New York Mellon and, do you remember that one? Which was a cinema complex in Whitchurch in South Bristol. In the early days of lockdown, the way they tried, amongst other things, to argue in the High Court that the lockdowns and COVID, because the cinema couldn't obviously open, gave rise to a frustrating event. There was a lot of discussion about it during lockdowns. But they failed. Again, the lockdowns weren't going to last forever, although it felt like it on occasion. And it'll only be a small amount of the time that would have to shut. The duration, I think, was a 35-year lease. And when it went to the Court of Appeal, they didn't even bother arguing the frustration. There's actually only been one case, and that's a strange one. Crell and Henry, 1903, when the coronation of Edward VII was cancelled because he was ill with peritonitis, and somebody had leased out a flat to watch the coronation for 2 days in June of 1902. And they decided that was a frustration event, but that was the whole of the time that, the duration of your agreement, and that's about the only thing that's come close to succeeding. So that's what they tried to argue. And would you like to know the decision?
Always, yes, please.
You can probably guess the decision on the basis of what I've said previously. And the fact it was a summary judgment, probably not a full court hearing, probably tells you something. The judge decided that, basically, they'd entered into, initially in the lease, a very onerous repairing obligation, and the tenants had a unlimited obligation to renew or replace, rebuild, reconstruct, renew or replace the whole of the building. Unless, basically, a very, very onerous repairing obligation, which suggests that they took on the risk. They also had entered into an agreement for lease, and the agreement said that anytime during the agreement for lease, the landlords would be the ones who were potentially liable for defects in the building work. But it was expected, it didn't seem to happen, but it was expected that when the lease actually was granted, they would be the ones, they would have to enter into collateral warranties with the deeds of warranty with the developers, the builders, to have a direct obligation. But, say the tenants had agreed that. The lease didn't or excluded any warranty that the property was suitable for the tenant's purpose. And basically the tenants had, parties had allocated the risk to the tenants, and the defects were foreseeable risks, which weren't unforeseeable. And for all those reasons, the fact that it was foreseeable and the risks had been passed clearly to the tenant and owners, repairing obligations and so on, it was not a frustration event. As you mentioned at the beginning, they also tried to argue that since the lease had been entered into, there had been some post-Grenfell legislation, the 2021 Fire Safety Act, came into force in England in May of 2022, and basically says that your obligations are enhanced. If there's residential properties, you have to have a fire safety risk assessment in relation to any internal doors which open into the common parts and any external doors and windows. And the Building Safety Act came into force in June the 28th, 2022. And that people with an interest in the property and local authorities and likes going to remediation orders to remedy sort of fire safety risks and structural safety risks. And the court decided that's a non-starter because you had the obligations anyway before the legislation all changed. So yet another case where frustration of a contract is possible, a lease is possible, but not on the facts.
So do you want to conclude by telling us why this one's important?
I think it's yet another it was a hefty claim. I know they had to pay about just over £9 million, £9.03 million in rent. But it's yet another desperate attempt to argue that leases can be frustrated. And there's a possibility they can. I remember when discussing it during the lockdowns, and heaven forbid if we have that again. But, if the lockdowns lasted, I don't know, off and on for a year and a half, then if the lease is only for a year and a half, you might just have a possibility of claiming frustration, but not, it's going to be exceptionally rare. I didn't think it had a chance of success.
And there we are. Thank you very much, Richard.
Thanks a lot, Lizzie. There we go.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.